Hello, welcome to Legalese. Legalese is a half-hour television program presented by the Northern Middlesex Bar Association. It's designed to present evidence that may be of interest to folks in the community. And today, I think we have a good topic. Today's topic is real estate title. The title of the show is Good and Clear Record and Marketable Title. And it deals with issues of real estate and real estate ownership. I'm joined today by two distinguished attorneys, Attorney Richard Larkin from Ayr and Attorney Robert Markley from Littleton. Welcome to both of you.
Thank you.
Thank you, Chris.
Richard, why don't we start with you? What is title?
Well, title, if you chose a non-technical word to cover it, I would say ownership. It gets into what it is you own, the extent of your ownership, and the quality of your ownership, and in this case we're talking about real estate.
Okay. Now, we chose this term, good and clear record and marketable title. That's a mouthful. What does it mean?
Well, I think everyone's familiar with the idea that you want to have good title to your property, and that gets involved in whether there are claims against it by others, and also possibly whether there's some technical problem with the quality of your ownership. Historically, those four words in that title to the episode here, good and clear, record, and marketable, have all had slightly different meanings in connection with title. Because the real estate market is now, one could say, beholden to factors outside it, such as government interests, insurance interests, things of that nature, it has become the case that the quality of title that someone has to have in the modern age is an amalgamation of these different historical legal qualities of title. And so that phrase appears in virtually any purchase and sales agreement that you will find. That's what you have to get.
That's the standard language in a standard form purchase and sale agreement. So let's break down those words and what they mean and what you're looking for when you're trying to determine that this piece of property that you're buying is actually owned by the person you're buying it from.
Yes. Well, that's a good way to get into it, because the idea of good title means that you have to have a title is a set of rights in the land, and the set of rights you have has to be real. It has to have come from someone who had a set of rights. Those rights may be subject to various claims, circumstances, but you do own something and it's real, it's good. And so it will have come to you possibly by deed, possibly by death, or some other means, a judgment of a court. And what you have has to be real, not fictitious. You can't, for example, have a deed to a different piece of property. That's not a good title. Clear means that, to some extent at least, it has to be free of defects or the claims of others. In general, title problems could be said to break down into two categories. One would be there's someone out there that may claim against you. Those are the deeply feared title defects. The other category would be there's some technical problem, some administrative or documentary problem about your title that makes it not what it should be, but the likelihood of a claim arising from it is small.
Okay.
So, well, for example, let me see now. There might be, for example, a suggestion on the record, or maybe off the record, that there might be some interest out there that may have a claim on the property, and you can't determine whether that exists or not. For example, there's an estate situation, and it isn't clear who the heirs were, so there may be heirs not accounted for.
Okay.
So that would be a situation where there's no real claim against the property, but it can't be demonstrated that there isn't.
So it's not clear.
Correct.
Therefore, it's not good.
Not clear.
So that's good and clear record that we're trying to establish.
Now, record has to do with the fact that the Registry of Deeds in any county where the property might lie and the probate and family court of that same county, anything that appears in either one of those venues, and the primary venue is the Registry of Deeds, and you could say for purposes of title the probate court is riding with it. Anything that happens there affects title to property, potentially, and the world at large is responsible, whether they know about it or not, for whatever is there.
Okay.
Another court, say the Superior Court, might have something going on in it that could affect title, but that is not record title unless it's brought to the record. So besides what's
Brought to the record, meaning recorded with that registry.
either in the Registry of Deeds
Registry
or
of
in some
Probate.
way funneled into the probate court, which then becomes part of the record. So, good or bad, in order to affect title to property, it has to be on the record. There can be claims that exist, they're not on the record, but they're potentially there, and that gets you to marketable.
Okay, so the last part of that phrase, marketable title.
Right.
What is that?
Marketable title has always referred to this concept. Considering what claims or defects in the ownership of property that may exist, would a prudent individual be willing to take those on and face the risk of whatever those claims or defects are? That was the traditional concept or definition of marketable title. And historically, if the only thing that you were guaranteed in your agreement, your contract, was marketable title, it was the case that a remote or unlikely claim probably would not render the property unmarketable. There had to be some realistic prospect that the defect or claim that you were concerned about would materialize. So marketable title by itself had to do with a prudent man making a judgment about what was going to happen on the ground. Record title has to do with what appears in the public record, and for a title to be good, you have to marry the two, which is why we have this kind of phrase.
Okay. So that's what constitutes what you are hoping to receive when you're buying property. Now, Robert, maybe you could go into some of the clouds on a title or some of the issues that may come up when your title is researched. Something that might come up that would be something that might cause some problems for you.
Oh, certainly. Well, as a practical matter, if you have internet access, you can check the Registry of Deeds website for the county where the property is located. It's Mass Land Records, MassLandRecords.com, just Mass Land Records. That's the home page. If you click on the county, you can search by name, property address, book and page number. If you know it, there's a number of search parameters that you can use. The registry, for a good title, you're supposed to go back 50 years, minimum.
Right.
The registry online has not gotten quite back to 1965 for everything. There's a lot of things, though. Some things go back further. It's just a matter of time for them to scan everything in.
So the registry is kind of now coming online with these abilities that didn't exist, let's say, 10 or 20 years ago.
Right. You'd have to go down physically to check the registry records yourself. You can see anything that's recorded, such as a homestead. A lot of people might have a homestead but not realize it. It's normally recorded when you purchase the property, but can be recorded anytime after. So you can see if you have a homestead, if you have that question. As far as clouds on title, the most common, I think, is the undischarged mortgage. So if you're looking to possibly refinance because the rates are still low or sell your property on the spring market, you can get a head start and check yourself to see if you can see anything that might be a problem. Basically what you can do is click on the hyperlink for each document, and then you can open it up and you can see the whole document and scroll through it. There will be a corresponding discharge. on the record that will reference the book and page of that mortgage. So you can do a quick kind of check yourself. Other things that I've seen quite often are tax liens. If you don't pay your property tax, the town can record a lien. If you don't pay your income tax, the state or the federal government can put a lien on the property. All of these require notice to you. However, sometimes it doesn't get delivered or mixed up, but you'll be able to see on the record. A few other issues are mechanics liens. If you've had work done in your house, say roofing or decking, and even if you've paid the contractor, if the subcontractor is not paid, they can put a mechanics lien. There are certain procedural steps that...
What is a mechanics?
It is a lien for a person that has provided physical labor to do some kind of work on your house, whether it's repairs, whether it's capital improvements, and they have not been paid for their services. Mm-hmm. There's a number of steps that they have to take to perfect their lien. I won't go into that. It's not really the basis, but essentially you would have to pay off that lien and then go after the general contractor to get your money back. A few other ones that don't happen as often are water or sewer assessments, if you haven't paid those. General town assessments, if there's an assessment to hook up a street to a sewer system, then many times they'll put an assessment on that house, and then they'll put a lien on record, and once you pay it off, they'll put up a discharge, essentially.
Now, Richard just talked about the records with respect to the Registry of Deeds and the Registry of Probate. You're talking about situations that involve the town now. And where would one obtain that information if you were the closing attorney, say, and you wanted to determine if there was any tax liens on the property?
It's pretty simple. You can go to the town assessor's office and get what's called a municipal lien certificate. Each town is a little bit different in what they charge, but it'll range from $25 to maybe $50 in that category. And then they will mail you, or you can go pick it up if you prefer. Mm-hmm. It's a one-page that will show the property taxes, if there's any liens for that, if there's water, sewer, anything outstanding that the town is claiming it's owed will show up on that certificate.
Does that certificate get recorded?
It does.
Okay. And what's the point of recording the certificate?
It's like any recording, it puts the world on notice to anything that's affecting the property. So a clean municipal lien certificate that doesn't show any amounts due to the town puts the world on notice, but particularly the buyer and then the seller if they turn around and sell it, that at least the town won't be claiming money owed that it could put a lien on the property for.
Okay. All right. Richard, you represent either a buyer or a bank. You've been presented with this situation where the buyer wants to purchase property. You're provided with a purchase and sale agreement. What do you do as far as researching that title?
Well, as a matter of fact, you wouldn't be researching the title until are you talking about an executed purchase and sales agreement?
Yes.
Oh, I see. Okay. Because I was going to say, I thought you were talking about reviewing a purchase and sales agreement for execution, but I would say this, because of some of the things that Robert mentioned, undischarged mortgages, which were a plague on the landscape not too many years ago, and it's still a problem. For some reason, the discharges never reached the record for various reasons. So, over recent years, the first I learned that I'm going to be involved in a piece of property, possibly even before a P&S is signed, if it looks like it's going to be signed, I checked the record for those kinds of things because, as Robert indicated, it's now possible to go online and you can find these things quickly from your desk.
That wasn't always the case.
So you can.
What was the case?
Well, you used to have to go to the Registry of Deeds and look up a bunch of books. Mm-hmm. Nowadays, fairly easily and fairly quickly, you can look at the mortgages that have been on the property, and then you can track the discharges. And if you see, for example, there was a mortgage for $250,000 on a piece of property, and then 2 years later there's one for $310,000, and that $250,000 mortgage is still there. Well, common sense tells you that was probably paid off. They refinanced, they got some equity money out of the property, and for some reason that discharge of mortgage for the older one never got recorded. One is well advised to start chasing those as soon as possible because they're not always easy to take care of. So you want to get a head start, the discharges, so-called missing discharges.
Sure.
Getting past that, most of the time now the buyer will be dealing with a banking institution, either a local or some cyberspace banking institution, but in any case, those institutions typically have attorneys that they use for closings, title work, and at some point you'll be charged with doing that job. If it's a client that I'm representing throughout, I want to get started on that title as soon as possible. Not all attorneys do this, but through the years I've usually done my own titles. I found it useful. And
mechanically.
Well, mechanically?
How do you, what do you do? You've been presented now with a deed that shows that this person's the owner. Mm-hmm. You've got to look back 50 years from that deed, right?
Yes, you do. That's,
so how do you do that?
On residential property, there's a statute that addresses that, and the statute provides that if the consumer, the buyer of residential property, I think it's 1 to 4 family if I'm not mistaken, I could be wrong about that, haven't read it for a while, but in any case, if the consumer, the borrower, is paying the bank's charges and the closing fees, then this statute comes into play, and it requires the title examination be at least 50 years, and then it has to go back farther than that until typically a deed is found that people say is on all fours, which is to say the deed on its face looks good. You have to go outside the deed, but first of all, the deed has to look good, plausible, properly done, and so forth.
So as you go back to that, I guess, starting point?
Starting point, yep.
As you go back to that starting point, what is it that you're doing to find each of these deeds?
Well, you go back to that starting point. Most deeds have what is called a title reference, in which the seller of the property at that time indicates where they got it, and the subsequent seller, and so forth. And through the successive deeds in the chain, you find out a record, a schedule, you might say, of the period of time during which different people owned the property and the instruments, the deeds and so forth, by which they acquired title. And that gives you time frames within which different people owned it. You then, I think Robert was going to address these things, but you then, in the Registry of Deeds, either in person or nowadays through this mass land records access that most of the registries have, you are able to look at the activity under that named owner, whatever might have happened, if people sued them and attached the property, if they gave mortgages, if other kinds of liens arose, anything that happened, if they sold off a piece of the land, and so forth. If they gave easements, maybe for a street widening or something, they might have given the town or the state easements for that purpose. All of these things can be found on the record, and moving successively through different owners, and then for a short period of time after they've divested themselves of title based on certain technicalities of the law, you find out what they did, and then you assess all of those activities or transactions. And that's how you determine whether title's good or not.
Okay. So, Robert, as far as going through the land records, maybe you could take us a little bit more into that as far as the computerized now version of what we're able to do and going online.
Sure. As I'd mentioned before, the website, each document that you see recorded will have a hyperlink that you can click on. on the right-hand portion of the screen, at least in Middlesex County, there's two formats of the website. Worcester County is different. I think Essex County is the same as Worcester. Middlesex County and I think Suffolk County use the same format.
Now, is there a push to try to get everybody together on this? Once upon a time, every Registry of Deeds was operating independently, right?
Yes.
And so now there's a push to try to get everybody under the same umbrella?
Somewhat. I don't think that will happen in the immediate future. I know that it would make things more streamlined and efficient, but it also includes costs that would be incurred. So I'm not sure where that really stands.
So it pays to deal with a local attorney who knows
absolutely
the lay of the land in the particular registry.
Yeah, absolutely. Correct? Well, you can't. I would not do a title search solely online. Doing it online is just a very quick way to see if there are some outstanding title issues that you'll have to deal with. It would still require a trip to the registry or have a title abstractor provide you with an abstract of the title. But it's just a way, as a practical matter, to get a head start on obtaining discharges. If you don't do that, what will likely happen is the lender's attorney for the buyer will get a title abstract, or they'll do it themselves, and then you might not find out until a week before the closing there's all these title issues that need to be addressed, and now you have to get an extension on the purchase and sale to deal with those problems. And it can take a while. Some lenders are quicker than others in responding to demands for discharges. There's a statute that deals with that the settlement agent, as the closing attorney, can demand a discharge by certified mail, and within 45 days they're supposed to send it. Doesn't always happen, but that's still 45 days.
Sure.
So the sooner you can get a start, the better. Now, as I said, I'd still go there, but at least it's a way for you to get an idea, even before you go to the registry, of some of the things that you're going to be looking for. Now, sometimes the hyperlink, when you open it, as I said, on Middlesex County, on the right-hand side of the screen, when you click on a particular document, it will show you, or should show you, other documents that are connected to it. So if you click on the mortgage, it'll show a discharge, or it'll show an assignment and then a discharge. But basically, the documents that are related to it. Some of the older documents, and this is why I wouldn't do it solely online, don't have that hyperlink. However, when you open the mortgage, say, there'll be what's called a marginal reference, which means somebody at the registry hand wrote in the book and the page. So the discharge, or the mortgage will reference, a future book and page where the discharge is, even though you might not be able to see the discharge online because it hasn't been uploaded yet, say.
So to what extent can you rely on this hyperlink service, I guess, that's being provided by the registry online?
Well, it's not foolproof, which is, it'll certainly require some physical research at the registry, but it is fairly accurate. I've had some issues. Normally, say if there's a mortgage recorded, and then there is say there's a deed recorded to a condominium, and then there's a recording of a plan. Well, they might give them, they might record it together. So, say the deed would say the plan's recorded herewith. So they recorded it together,
right,
but it won't have a hyperlink to the plan.
Right.
So there are some, I don't know if they're glitches or if that's just how the system's designed, but there are some things that you just can't see that you would want to see as part of your search.
Okay. You both have used the term, I think, title abstract. Robert, what is a title abstract?
There are individuals, a lot of them specialize in searching titles there at the Registry of Deeds pretty much every day for the most part, and that's usually all they do, is just search titles for attorneys, and they will provide a copy of everything that they found in the title. So you'll have copies of mortgages, copies of deeds, should have discharges, basically anything that's on record that has the potential to impact the title.
Okay. And Richard, we got maybe a minute left. Richard, can you explain what is a grantor's index versus a grantee's index?
Yes, well, there are two great indices in the Registry of Deeds, the two you mentioned, mm-hmm. and then there are other secondary index collections. But the grantor index lists everyone who either is a grantor of property, a seller, or is deemed to be a grantor. So, for example, if someone sues you and attaches your property, they have taken something, a lien from your property. You didn't want it to happen, but you're treated as a grantor for that purpose.
Right.
And in truth, most title examinations are done in the grantor index because you're interested in what the owner of the property did. The grantee index can be useful if for some reason you're stymied in following the chain. You can sometimes get information from the grantee index that allows you to continue your search. But
so title comes from the grantor, goes to the grantee.
Correct. That's correct. Yes.
All right. There's a lot more that we could talk to on this subject, but I thank you both for appearing here. Obviously, you're both a wealth of knowledge, and like to tap into that a little bit more, but we can't right now. Unfortunately, that's the end of our show. I thank you all for watching. I would suggest that anything you hear here should not be taken as by you to be advice on a particular matter. I would suggest that if you do have particular matters, that you take those to local counsel and deal with a one-on-one consultation with local attorneys. I'm Attorney Christopher Lilly. I'm here with Attorney Richard Larkin and Attorney Robert Markley, and I thank you. Good night.
I wasn't talking too loud. I wasn't talking too loud.